Hi, it's Catherine Franke. It's June 5th, and since I was forced to retire from Columbia Law School last January, I guess I kind of have kept teaching, but not so much in the classroom, but more in this context. So I have a different student body, in some respects, a bigger student body, but what I'm trying to do is teach. So I offer you that to start this video off today because I'm going to get in the weeds a little bit on the law. So I ask for your patience and just sit through this because it's really important. So in 1863, President Lincoln signed a law called the False Claims Act. He signed this law because there was a huge amount of fraud being committed against the United States government during the Civil War by contractors. People were providing services and goods to the United States government, particularly as part of the war effort. So military contractors committing fraud. They were doing things like selling to the government horses who were lame, or food that was rancid, or guns that didn't work, or buggies that didn't have a wheel, stuff like that were the basic tools of the military campaign. So the False Claims Act of 1863 says that if you provide to the government or receive from the government an economic benefit, and you do so fraudulently, you do so in a way that violates the legal agreement that you have with the government when you reach an agreement to sell the government something or to receive a benefit from the government, you can be held liable for that fraud, for the value of the thing which you sold to the government or you received from the government. But more importantly almost is that the law also contains something called treble damages, which means that if you're found to have engaged in some kind of fraud in relationship with the government, you will be penalized 3 times the amount of the actual damage that the government experienced. So there's a very high penalty in False Claims Act cases. So why am I bringing this up? Well, over time, these cases largely since 1863 have been in the area of Medicaid fraud, certainly military contracting. There was a real uptick in False Claims Act cases brought during the Reagan administration when Reagan grossly increased military spending, tons of military contractor fraud at that point. Cases are sometimes brought against Big Pharma for encouraging off-label use of drugs that then gets compensated through Medicaid or Medicare, but mostly Medicaid payments. That's considered a violation of the False Claims Act. More recently, people who receive PPP loans fraudulently were prosecuted under the False Claims Act, and a number of people were found to have violated the terms of the PPP by fraudulently saying they were operating a business and had to lay off staff or weren't able to operate their business because of COVID. So the False Claims Act is something most people haven't heard of, but it's a very important law that deals with fraudulent dealings with the government. Well, why do I raise it now? Why it isn't just an intellectual issue, although I like those too. A couple of weeks ago, Pam Bondi, the Attorney General, issued a memo announcing the Civil Rights Fraud Initiative, and she cites the False Claims Act, and she says that this is the Justice Department's primary weapon against government fraud, waste, and abuse. And what she goes on to say is if there is anybody who receives federal financial assistance, federal grants, the whole range of reimbursements from the federal government for health care, for really anything, federal contracting of any sort, if that entity encourages anti-Semitism, refuses to protect Jewish students, allows men to intrude into women's bathrooms, or requires women to compete against men in athletic competitions, and then later says also if you have a DEI program or officer or any kind of equality measures in your workplace or business, that they will treat as fraud because they see those things as illegal. And so she announces this civil rights fraud initiative that will be staffed considerably with people across the country, people that work for the Justice Department and other divisions of the federal government to ferret out this kind of what she calls fraud. Now, that's a problem. I'm going to explain in a second why. But what's even more important about the False Claims Act is that it contains this provision called qui tam, which means that private parties, you or I, could file a lawsuit in federal court alleging a False Claims Act violation by any party who receives some sort of federal financial benefit. Now, usually private parties can't enforce the rights of the government. The government has to do that. That's why we have the Department of Justice and government lawyers. But with the False Claims Act, almost uniquely, private parties can go to federal court, file a complaint, and say, company A, B, or C is engaging in military contracting fraud. Dr. So-and-so down the street, I think, is engaging in Medicaid fraud, or Columbia University is engaging in activities that are, in my view, anti-Semitic or fail to protect the rights and interests of Jewish students. And so how that works is that private party files a complaint in federal court. They then also share that complaint with the Department of Justice, as well as a detailed memo setting out their reasons why they think that entity, let's say Columbia for the moment, has engaged in activities that violate the False Claims Act. The DOJ then has 60 days to investigate, think about it. Then courts will allow them more time if they have good reason to ask for more time to investigate it. And then DOJ can intervene in that case as a party, as a co-plaintiff, to prosecute the False Claims Act complaint. Or if they decide not to, then that individual can proceed on their own. And if they're successful, they will receive 15 to 30% of the recovery of whatever the damages plus treble damages are that might be won in that case. So there's a financial incentive for private parties to bring False Claim Act cases. What we're starting to see, and this is why I'm particularly troubled right now, is that there are actors, David Abrams being one of them, who is a pro-Israeli, pro-Zionist lawyer in New York, has been bringing lawsuits against organizations like the Carter Center, the Middle East Institute, the New Israel Fund, claiming that they are engaging in anti-Semitism or worse, material support for terrorism by, in the case of the Carter Center, hosting a conference at which there were people, Palestinian advocates, Palestinian politicians in attendance who received bottles of water, snacks at lunch, things like that. That was the material aid that Abrams claimed had been funded by the Carter Center with, in part, federal funds that were material support for terrorism. Thankfully, that case was dismissed, but in other cases, like with the Middle East Institute, where there were similarly, I think, frivolous claims made of support of terrorism, the organizations may end up just settling the case and paying out significant money because they want to avoid either the cost of long-term litigation or, worse, the cost of actually being held liable for treble damages. And that is what the Middle East Institute did. So this new initiative from the Department of Justice, at the end of this memo that she wrote, she is encouraging private parties to basically act in sort of as private vigilantes, bringing False Claims Act cases against organizations, particularly ones that are have been targeted by the Trump administration, either for anti-Semitism or DEI more generally, as an additional weapon to punish them. So Columbia had its funds pulled, Harvard had its funds pulled. Now the DOJ can bring its own False Claim Act cases to impose additional penalties, but so can private parties. So I can imagine a scenario where some of my colleagues at Columbia University who are behind and supporting the Trump administration's campaign to take down Columbia University could on their own file False Claims Act cases in federal court. You know, I've got colleagues in the law school who know how to do this and are probably willing to do so at the behest of the Trump administration to increase the pressure on Columbia University. And the last thing I'll say is that I'm quite worried that they will take the position that one's nonprofit status, 501c3 status, counts as a federal benefit. Now, courts by and large have not been really open to this argument, but we're in another world right now. And they may say that the fact that you don't have to pay taxes basically counts as a benefit, therefore rendering you subject to the False Claims Act. And then a tax on 501c3s, nonprofits, can be brought by the government and by private parties against all manner of nonprofits who are engaging in activities that have to do with racial justice, trans rights, the rights of Palestinians, etc. So keep an eye out for this. Because this is a new weapon. It's not new, it's been around since 1863, but a weapon that's getting new attention in the way that the Trump administration and its allies, civilian allies, are targeting people and groups they disagree with.